In this video, we will demonstrate Pakistan's legal system and some of its aspects. So first, how did Pakistan's legal system develop historically? The British Empire expanded during the 18th century. And among the countries of the British Empire were the countries of the British Raj, the imperial rule of Britain over what was called British India, including countries we know today as Pakistan, India, and Bangladesh. In 1935, the Parliament of the United Kingdom passed an act called the Government of India Act, which granted British India sovereignty under the British Crown's rule. Conflicts arose in British India between Muslims, who were considered a minority, and Hindus. And after constant calls for the establishment of an Islamic state, Pakistan finally gained its independence in 1947. Upon independence, the Government of India Act of 1935 was the base for Pakistan's provisional constitution and its legal system.
Now, what are the sources of law which Pakistan's legal system depends on? Pakistan's legal system depends largely on precedents, in which the superior judiciary creates decisions binding to the subordinate judiciary. Secondly, on legislations, in which a bicameral parliament sets the laws. Thirdly, on customary rules, which are mainly based on Islamic principles and gender differentiation. And finally, on statutory interpretation, in which judges, when legislations are ambiguous, on their own sense of right and wrong, to decide the disputes according to the legislator's will.
How did Pakistan's legal system diverge from the English common law system? The Government of India Act of 1935 adopted the common law system. So Pakistan also adopted the common law system in its provisional constitution. The legal, judicial, and court systems of Pakistan also adopted the common law model even after the British rule ended. Even though the Pakistani constitution was amended in the years 1956, 1962, and 1973, this did not drastically alter the influence of the common law system on Pakistan's legal system. In addition, the common law system was followed in company law, tort law, property law, and trust law.
Which similarities still exist between Pakistan's legal system and the English common law system? The first similarity lies in the four levels of jurisdiction of both systems. Second, both resort to precedents as the main source of law. Third, the codification of law has increased in both states. In addition, both systems rely on an adversarial model in trials. And finally, a constitutional court does not exist in both systems. The Supreme Court of each state is the only court which has the competence to investigate constitutional matters.
How are courts structured in Pakistan's legal system? The court structure in Pakistan is made of 4 levels of jurisdiction, with some complications. The first level of jurisdiction in Pakistan's court structure takes one of 3 paths: a civil, a criminal, or a special path. Civil courts of the first level consist of 4 judges. The civil judge of the third class tries civil suits up to the value of 20,000 Pakistani rupees, the official currency of Pakistan. The civil judge of the second class tries civil suits up to the value of 50,000 Pakistani rupees, while the civil judge of the first class tries the other civil suits. On the other hand, the senior civil judge distributes the cases to the other civil judges and performs the duty of a guardian judge. Criminal courts of the first level consist of 3 judges. The magistrate judge of the third class tries offences punishable up to 1 month imprisonment and 5,000 rupees fine. The magistrate of the second class tries offences punishable up to 1 year imprisonment and 5,000 rupees fine, while the magistrate of the first class tries offences punishable up to 3 years imprisonment and 50,000 rupees fine. The special courts are tribunals for special matters created under special laws and enactments. There are numerous special tribunals such as family courts looking into matters related to personal status, and juvenile courts looking into matters related to minors.
Going back to the concept map showing the Pakistani court structure, we notice that the second level of jurisdiction consists of only two paths now, either a civil or a criminal one. The civil courts of the second level consist of district judges who investigate appeals against the decisions of the first level civil judges, and additional district judges who also investigate appeals against the decisions of first level civil judges whenever the load is too heavy to be carried by district judges. On the other hand, the criminal courts of the second level consist of session judges who investigate appeals against the decisions of the first level criminal judges, and additional session judges who also investigate appeals against the decisions of the first level criminal judges whenever the load is too heavy to be carried by the session judges. The third level of jurisdiction is the high courts. In Pakistan, there is one high court in each province, one in Lahore, one in Peshawar, one in Quetta, one in Karachi, and one in the federal capital, Islamabad. These courts are appellate courts which supervise the decisions of all the courts subordinate to them.
The fourth level of jurisdiction, the Supreme Court. It is at the apex of Pakistan's judicial hierarchy. It has a permanent seat in Islamabad, as well as branch registries in Lahore, Peshawar, Quetta, and Karachi. Its competence extends to legal disputes, constitutional disputes, intergovernmental disputes, human rights matters, and a check on military power. But also, the Supreme Court has a Sharia appellate bench empowered to review the decisions of the Federal Sharia Court regarding religious Islamic matters. The Federal Sharia Court was established to guard Islamic values in Pakistani laws. It has the competence to examine any law that may be in conflict with the injunctions of Islam, and to examine decisions of criminal courts relating to the application of Islamic law penalties.
What special feature does Pakistan's legal system have? Pakistan's legal system is a mixture of common law and Islamic law. This special feature is shown in Pakistan's constitution and in hudud ordinances. Pakistan's constitution declared Pakistan an Islamic republic and Islam as the state religion. It also stated that all laws would have to be in accordance with the injunctions of Islam as laid down in the Quran and Sunnah. On the other hand, the hudud ordinances are laws in Pakistan that were enacted in 1979, replacing parts of the British-era Pakistani Penal Code. They punish for crimes against Islamic Sharia law, such as property theft, zina, and alcohol consumption. It includes punishments such as amputation of the right hand, amputation of the left foot, stoning to death, public whipping, or imprisonment.